Okay, so relative to multiplicity. Multiplicity exists when a defendant is charged in more than one count for a single offense. And the double jeopardy provisions of the state and federal constitutions protect a defendant from being punished twice for the same offense. Under Wisconsin law, we employ a two-pronged test to determine whether charges against a defendant are multiplicitous in nature. First, whether the charged offenses are identical in law and fact. And second, if the offenses are not identical in law and fact, whether the legislature intended the multiple offenses to be brought as a single count. In this particular case, the defense is arguing that the two counts relative to hiding or burying a corpse is charged in count 4, and count 2, mutilation of a corpse, are multiplicitous. So looking at the elements, which is one of the standards that has to be reviewed, I need to look at whether or not the offenses are identical in law and fact. As to the mutilating a corpse, there are two elements. It's first that the defendant dismembered a corpse, and second that the defendant dismembered the corpse with the intent to conceal a crime. Looking at count 4, the two elements of hiding or burying a corpse are one, that the defendant hid a corpse. Second, that the defendant hid a corpse with the intent to conceal the crime. There clearly are different elements in law relative to the two offenses. As to the difference in fact, there are different acts that would be different actions that would be involved in dismembering a corpse versus hiding a corpse. So I think in this particular matter, the two offenses are not identical in law or fact. I next need to look at whether the legislature intended that multiple offenses be brought as a single count. And in so doing, you look at whether or not the legislature, in the drafting and creation of the statutes, set out different elements under Blockberger that amounts to the fact that their intent was to allow for different crimes to be prosecuted under the same subsection. At this point in time, looking at the facts and looking at the law and doing an elements-only test, I am going to find that the two offenses moving forward are not multiplicitous and that they are allowable. So I'm denying the defense motion relative to multiplicity. Defense.
Yes, I made a motion for directed verdict on all counts, Your Honor.
Do you wish to make any further argument?
No.
State.
Not unless you would like an argument.
No. So what I can tell you, Mr. Anderson, is at the close of the state's case in chief, what the court has to do is has to look at the evidence in the light most favorable to the state. So looking at the evidence in the light most favorable to the state, was the evidence adduced, believed, and rationally considered sufficient to prove guilt beyond a reasonable doubt? Or in other words, has the evidence that's been presented during the course of this trial, in the light most favorable to the state of Wisconsin, could a reasonable jury find you guilty? Looking at the facts underlying this matter, the evidence that's been presented during the course of this trial, to some extent, would be that on April 1st, you were at the Twisted Fisherman with Sade Robinson, that you arrived at 5:09, that she arrived at 5:20, that you both left the premises at a 6:24, that you then proceeded to Duke's on Water, arriving at 6:35, leaving the establishment at 9:04 p.m., that you proceeded to Anderson's home, 3161 South 39th Street, and arrived approximately 9:20 p.m. What we know is that on April 2nd of 2024, at Warnemont Park, at 2:53 a.m., the Civic arrived. At 4:32, the Civic departed. We know that on that same day, the leg of the victim was found. What we also know is that we watched a number of videos that tracked the progress of the vehicle, the Civic, around different aspects of Milwaukee. The videos at no point showed the driver or whether the driver was the sole occupant in the vehicle, at least not clearly. At 4:44 a.m., there was a white spot at a window and a lighter flashing or a lighter appearance in the driver's seat. whether the white spot was a white hand or the white shadowing was a white person in the driver's seat, or whether that was a glove, that's going to be left to the weigher of credibility. At 7:30 a.m., we know that the Civic was set on fire behind the abandoned building. We know that the seat was in a position that fit a person who's 6'1". We know that your measurements are that on the time this happened, you were 6'1" and a weight was approximately 180 pounds. We heard the testimony that the value of the Civic was approximately $20,000. And based on the videos that were presented, a reasonable jury could conclude that that was you, that was in an approximate distance from the burning vehicle, that you left the area of the burning vehicle shortly after it appears it was set on fire, that you traversed and entered a bus at 8:07 a.m., that you exited the bus at 8:34 a.m., that you were arrested on April 4th, and during the course of the arrest, you were visibly shaking. On April 4th, 5th, and 16th, search warrants were executed at your home. At Galena Park on April 5th, there were parts of the victim that were recovered in the form of different pieces of flesh as well as a left foot. There was blanket found, small flesh, bone, and large piece of human leg on the 6th, and there were ball joints with ligaments recovered on the 7th. From the testimony that was adduced during the course of this hearing, I don't think those bloody gloves that were found on April 9th had anything to do with anything. And we know that the torso with the arm were recovered on Marina Road on the 18th. We heard the testimony from the medical examiner that the death was homicide by unspecified means. And we heard the Life 360 and phone information and tracking information, which reflect that the phone of Sade remained at your house until 9:24 p.m., that the phone ultimately thereafter was not stationary, that it went down Capitol to the Mitchell Parkway to Warnemont Park, remained static at Warnemont from 2:40 to 4:33. It was in Warnemont Park, I believe, from 3 to 4:30 a.m. The last communication with the phone was on East Howard when the battery died. We know that Sade was reported missing on April 2nd, that you were the last person in communication or in presence publicly with her, that the videos of your home were poor quality. The testimony by Detective Rachel Smith was noteworthy. She indicated that she spent hundreds of hours viewing this video of your house and watching those hundreds of videos, and she basically saw the arrival at 9:20 p.m. and that the Civic departed on April 2nd at 12:47 a.m. She went through all of the testimony relative to the timing about the gate opening, the outdoor movement and gate not opening, the silhouette exiting the gate the same size as the fence at 11:25, the light going out at 11:27, 11:42 a person goes into the premises, the motion light goes on for human movement with a person the size of the fence at 11:56. At 11:58, we have human movement at the back gate area. At 12:12, we have the gate closing again. 12:42, we have human movement inside the premises. And ultimately at 12:47 and 20 seconds, we have the Civic leaving the house. We also have the fact that on the bus video, you returned to your residence at 8:42 a.m. wearing the green hooded sweatshirt and dressed differently. We have the fact that you went to the dugout on the following day for work. Noteworthy, we have the photos that were recovered from your home. It's noteworthy that the photos of Sade reflected her buttocks and her underwear pulled down as if the underwear were pulled down with the pants and that it rolled over the pants, which is pretty much just how they were found in the trunk of the vehicle that was set on fire, that you were found walking away from. We also have the fact that there's a photo of a white hand grabbing her right breast, and the right breast is the breast that was dismembered from her body on the torso that was recovered. We also have the fact that there was the photo of bleach and what not to combine with bleach, which I think a reasonable inference could be that someone on your phone was looking for information relative to how to clean up something or a crime scene. So looking at all of these factors together, it's a circumstantial case, but as we know, according to our jury instructions, circumstantial evidence may be found to be stronger than direct evidence. And at this point in time, I am going to find that a jury acting reasonably could convict you on all charges as posed. So I'm going to deny the defense motion, and what that means is I'm going to allow this matter to proceed to the jury. They have a different balancing than I have. So at this point, my view is, in the light most favorable to the state, do they have the means to convict? A jury at the conclusion of the case, their job is to determine whether or not the state has proven each and every element beyond a reasonable doubt. So I deny the defense motion. Have you spoken to your client, or do you need a moment to speak to him?
No, 1 minute, please. Okay, I've spoken to him.
Okay. Have you spoken with your client relative, well, let me ask you this. Do you intend to present any witnesses other than the defendant?
Defense rests.
Okay. So, Mr. Anderson, have you discussed with your attorney your constitutional right to testify as well as your constitutional right not to testify?
Yes, Your Honor.
And has your attorney answered all your questions?
He has, Your Honor.
And you understand that in a criminal case, you do not need to prove your innocence, but the state must prove your guilt beyond a reasonable doubt. Understood?
Yes.
And you understand that if you choose to testify, you would be subject to cross-examination by these prosecutors.
I understand.
And you understand if you choose not to testify, that cannot be commented on by anyone. That cannot be used against you. Understood?
Yes.
And have you had enough time to discuss this decision to testify or not to testify with your lawyer?
Yes, Your Honor, I have.
Have your attorneys provided you with their professional opinion?
They have.
Has anyone, including your lawyers, made any promises to you or offered you anything to arrive at this decision?
No, Your Honor.
Has anyone, including your lawyers, threatened you or coerced you in any way to arrive at this decision?
No.
Do you believe you're making this decision freely and voluntarily?
Yes.
Do you have any questions for me about this decision?
No.
Do you believe you're doing this with full understanding?
Yes.
Have you used any drugs or alcohol in the past 24 hours?
No.
Are you taking any medication that would affect your understanding of these proceedings today?
No.
After thinking through everything we just talked about just now, is it still your decision not to testify?
That is my decision.
Attorney Cotton, have you discussed with your client his constitutional right as well as his right to testify as well as his constitutional right not to testify?
Yes, just to be clear, it's been a subject of course discussion throughout this case, including the last 2 nights after trial. We've had jail visits to discuss that. Mr. Finling and I have both discussed it with him.
And are you satisfied he understands what his rights entail?
He does.
And have you advised him of your professional opinion?
Yes.
And are you aware of anyone making any threats or promises using any force or coercion towards him in respect to this decision?
No, I'm not aware of any such threats.
Are you so satisfied that he's making his decision freely, voluntarily, knowingly, and with full understanding?
Yes.
I am as well. I, in fact, find that the defendant is waiving his right to testify, and he's doing so freely, voluntarily, knowingly, and with full understanding. Let's proceed at this point in time to do a conference relative to jury instructions and verdicts. I've printed off new verdicts for you. Prior to the matter being called, the state indicated they were seeking a lesser included on count 1. I did add in 1018. Is that still the state's position?
It is.
Defense, did you wish to be heard on that?
Yes. Give me 1 minute, please.
Okay.
It's a new development. Okay, no, I don't need to be heard on that, Judge. I don't have any, I've discussed it with Mr. Anderson, and I don't have an objection to that.
It's basically what I need to look at is whether or not a jury acting reasonably based on the evidence presented during the course of the trial could come to a reasonable decision on a lesser included. And that's the analysis the court has to make when a party requests a lesser included. In this case, I find it's appropriate, and I will add in the lesser included, so we will use 1018. So my intention relative to the instructions would be 100 opening instruction, 115, 1 defendant, 4 counts. Count 1, 1018, first degree intentional, followed by first degree reckless. Then moving on to 1193, mutilating a corpse. 1408, arson of property other than a building. 1194, hiding or burying a corpse. Then proceeding on to evidence defined, 103. Then 147, improper questions. 148, objections of counsel, evidence received over objection. I don't think I ever struck any testimony. Did I?
I think
It was
there
asked, but then I think you withdrew.
Yeah, I don't recall any testimony being stricken.
Attorney Cotton?
Yeah, there was one comment where a witness had said "they" instead of the civic. That was struck, but
I'll leave it in. It's it's 2 sentences.
yeah.
157, remarks of counsel. State, I'm sure you want 170, circumstantial evidence, and 172, circumstantial evidence, flight, escape, concealment.
Yes.
Then 190, weight of evidence. 195, jurors' knowledge. I put in 200, opinion testimony. I took out the word expert because I think that's inappropriate to have in the title. 141, I assume the defense is requesting.
Yes.
201, opinion of a witness. I put that in relative to Detective Donahue's testimony when he was providing an opinion as to his hearing of what was the audio portion of the video. Any objection to that?
No.
And that's,
201.
no, I know that. There's also the recordings played to a jury 158
So I just,
covers that, which would cover that.
okay, I can put that in if you'd like me to. I think that it doesn't add much to anything, but I'm happy to.
I think
Okay.
it's redundant,
Yeah.
and what the jury needs to be instructed on is covered in 201. Or, yeah, 201.
Do you want 158 or do you want to just stand with 201?
No, I think it's, I was just pointing out it's essentially covered under 201, so that's fine.
Okay, so you're not requesting an additional one.
Right.
Okay, then I did put in opinion testimony. Again, I took out expert and I put in the hypothetical question because there were a couple of hypotheticals posed. I'll remove 327 because the defendant didn't testify. We had one witness with a prior conviction, but was the question ever asked if he had a prior conviction?
No, it wasn't relevant.
I did not ask him.
And I don't think defense did either. So I'm